The courthouse nobody could subpoena. They convicted Ray Delacroix of murdering his wife in 1987. Then someone found the property deed to the old courthouse annex, and it proved the room holding the evidence had stopped being government property 9 years before anyone noticed. Here's what the state told the jury. Sandra Delacroix was found dead in the couple's kitchen on a Tuesday morning. Blunt force trauma. Ray had no alibi past 11 p.m. A blood-spatter expert testified the pattern on his shirt cuff matched the angle of the fatal blow. The jury deliberated for 3 hours. Life without parole. The case went into the archive, and the archive went into a building nobody thought to ask about again, the Harlan County Courthouse Annex, a squat brick structure 2 blocks from the main courthouse, built in 1961 to hold overflow evidence and old case files. In 2019, a demolition crew showed up to gut the annex for a parking structure. In a subbasement, sealed behind a wall that hadn't been opened since the Reagan administration, they found 4 steel lockboxes. Inside one, the original crime lab bench notes from the Delacroix case, not the typed summary the jury saw, but the analyst's handwritten working pages. Chain of custody, for anyone who's never had to sit through the phrase, just means the paper trail proving evidence wasn't tampered with between the crime scene and the courtroom. These pages had never been logged into that chain. They'd never left the building. The bench note said something the typed summary didn't. The analyst had measured the spatter angle on Ray's cuff at 31 degrees. The trial testimony, the version the jury heard under oath, put it at 60. That's not a rounding error. That's the difference between a blow struck standing over the victim, which is what the prosecution argued, and a blow struck from across the room, which fits an entirely different sequence of events. 2 numbers, 1 conviction. Nobody at trial ever saw the page where 31 became 60. So why did it take 32 years for anyone to ask? Because of the deed. In 1994, Harlan County sold the annex to a private developer to cover a budget shortfall, then leased back 2 rooms for storage, informally, on a handshake never refiled with the county clerk. The building stopped being county property, and a subpoena only reaches records held by the government or by someone the government controls. Once the annex belonged to a private owner who'd forgotten what was even in his own basement, the court had no legal path to the boxes inside it. Defense attorneys tried twice in 2001 and 2008 to get a judge to order access. Both times the motion was denied, not because the evidence didn't matter, but because, on paper, it no longer existed anywhere the law could touch. But the bench notes weren't the strangest part of what was in that lockbox. Underneath them was a second document, a witness list handwritten with 1 name circled twice, a neighbor named Lloyd Purcell who was never called to testify. Cross-referenced against the original police log, Purcell had reported hearing Sandra Delacroix's voice on the phone at 11:40 p.m., 40 minutes after prosecutors told the jury she was already dead. 1 overlooked neighbor, 1 circled name. If Purcell was right, the entire timeline the state built around Ray Delacroix collapses because he has an alibi for the only window that mattered. The county attorney who tried the case in 1987, Everett Boone, was appointed circuit judge in 1996. The same year the annex lease quietly lapsed, and nobody filed the paperwork to renew it. Nobody has ever proven that was more than bureaucratic neglect. But Boone sat on both appeals that tried to force the annex open and recused himself from neither. Ray Delacroix is still in Edaville State Prison. In 2021, a state review board reopened the file, cited the bench notes as newly discovered evidence, and then quietly closed the review 18 months later, citing insufficient grounds, without ever explaining what grounds would have been sufficient. The lockboxes are back in evidence storage now, at the real courthouse this time, properly logged, properly subpoenable. Nobody has retested the spatter. Nobody has found Lloyd Purcell, who moved out of state sometime in the early 90s and hasn't surfaced since. The building that hid the proof for 3 decades is a parking lot now. The question that building never answered is still sitting there, unresolved. If a courthouse can quietly stop being a courthouse, how many other rooms like it are still standing, still sealed, still holding pages nobody has ever been legally allowed to read?